explore access to justice issues for newcomers and for other individuals in our community with communication barriers. Often access to justice has been denied or systematically out of reach for our own First Peoples in Canada. And for us as settlers on this land, we deeply appreciate the contributions of the traditions of the Algonquin, Anishinaabe, and other Indigenous peoples in shaping and strengthening our community, our province, and our country as a whole. As an access to justice organization, we encourage action and deliberate work to ensure that reconciliation moves forward in our community and in our country. Today's event would not have been possible without our project funder, the Law Foundation of Ontario, and we thank you for your continued support of Connecting Ottawa. You will note that there is a chat function and a Q&A feature in Zoom that you can use. If you're experiencing any technical difficulties, please send a note through the chat function. And if you're bumped out or you leave the session, please re-enter through the same link that you used to join us today, or email info@connectingottawa.com for any help. We encourage you to post any questions that you might have for the speakers through the Q&A function. So it's not possible to ask questions live today in the webinar, but following the speakers' formal presentations, we will pull questions from those that are posed in the Q&A for our speaker to answer. So please, if you have any questions, don't put them in the chat, please put them in the Q&A function.
Thanks, Heather. For those of you who don't know me, I'm Gina Grosnick, the project manager of Connecting Ottawa. Through our work, we understand that there are a number of unique issues that newcomers and vulnerable populations face in regards to their employment. Today is the first part of a two-part series on frequently asked employment law questions. For your reference, we have created a document on employment law resources in Ottawa and throughout Ontario. A link to this information will be posted in the chat box shortly. We encourage you to share it with others who are not here today. It's now my pleasure to introduce to you our speaker, Jamie Lefebvre. Jamie, your camera's on, that's great. Jamie is a labor and employment lawyer with a diverse background and work experience. She has been a member of the Canadian Armed Forces Primary Reserves since 1993 and continues to serve part-time. Jamie may be familiar to some of you as she worked at Community Legal Services of Ottawa, practicing immigration and refugee law, as well as other aspects of poverty law for a number of years. She then joined Jewett McCluskey as an associate in February 2020, where her practice focuses on labor and employment law. So I'm going to turn the session over to Jamie. And just a reminder, Jamie, that I'll be forwarding the slides. So please indicate next slide when you'd like to move on.
Thank you, Gina, for that introduction. And thanks to Connecting Ottawa for inviting me here today. If we want to advance to the next slide. This week's presentation, thanks to Connecting Ottawa, is part of a series. And next week, a colleague from Toronto, John No, is going to be providing other employment law related questions. And so today, I'm only going to be covering employment contracts, cash payments and penalties, overtime, sick leave, Canadian experience, and harassment in the workplace. I do expand on a few of those things and can answer some of those questions. I do want to highlight that this presentation is for informational purposes only and not meant to replace any legal advice. I have crafted these answers really around Ontario legislation. And so if you're working for an employer that is federally regulated, this information would be different, as well as outside the province. And it's also geared towards employees, not contractors, and not what some people would call gig workers. So there is different kind of aspects to those employment relationships, and this information is not necessarily directly applicable. There's also a number of exclusions from the Employment Standards Act. I'm not going to specifically enumerate them here today, but they are available on the Ministry of Ontario's website if you're wondering if perhaps one of your clients is subject to one of those exceptions under the Employment Standards Act. Next slide, please. A big question we do see from people in the employment-related field is, what if I don't have an employment contract? And the short answer, of course, there's always a short answer and a long answer with lawyers. The short answer is that employment contracts can be verbal or written. And what that means is that even if you don't have an employment contract, there are certain things that are implied to be part of your contract, and that those duties on both the employee and employer do continue to govern the employment relationship. Additionally, there is a number of laws that apply. So I gave you the example of the Employment Standards Act, which is the primary provincial law that governs the employment relationship. There's also human rights legislation. There's different employment laws in different provinces. There's also different laws if you are in a unionized workplace. Occupational health and safety laws, whether it's provincial or federal, do apply, as well as some laws in specific industries that do apply in the employment relationship. And so it's easy for me to generally say courts can impose implied terms into the contract. But as we are speaking here today with Connecting Ottawa, we know that not everybody, in fact, a lot of people don't have the means to contact an employment lawyer. And so if you are wondering, well, what does that mean for me as an employee? What's an implied contract? I did make a list of some implied contracts over and above what the general legislation does provide for. And so, first of all, the Employment Standards Act in Ontario covers things like hours of work, breaks, wages, overtime, different types of leaves like parental leave and family leave, things that you would find potentially that could be covered by employment insurance, vacation, termination, and severance, which is something John Noe is going to get into next week, and a number of other things. My experience really is that the Employment Standards Act is a bare minimum legislation. And so some of the benefits of an employment contract can clarify how that employment relationship works, but that employment contract can never contract out of the minimum standards that are provided for the Employment Standards Act. I mentioned that there are implied terms that sort of govern employees and employers. So employees generally have an obligation to obey sort of what they call the lawful orders of the employer. Sorry if that sounds too militaristic, but that's also how it's framed, generally speaking, in employment law. There's an implied obligation to cooperate in advancing the employer's continued interest, implied obligation not to compete, although there is some specific information in the Employment Standards Act as well, and to provide to protect confidential information and to avoid lateness, absenteeism, an implied obligation to be honest, an implied obligation to perform work competently and safely, and to avoid intoxication, avoid harassment, and to give reasonable notice of resignation. That's a pretty long list that applies to employees. And so you won't actually probably be very surprised that the employer's list is shorter. So employers are required to have reasonable notice of termination and other sort of essentially a duty of fairness and other things that would apply in the common law. Now, why is that important to you? Well, if you're thinking about what the contract is asking you to do, if you are going to engage in an employment contract, read for all of those types of terms as well. And if you have any opportunity to go on the ministry and look at those obligations, then please do that. A lot of people are, you know, in a position where once you get a job, you're so happy, you just sign the contract and move on. And once you sign a contract, if it's something that the Employment Standards Act doesn't provide for, that could essentially be it. And I'll give you a common example that we see. Sometimes people will sign away some common law termination notice period. So John's going to get a lot more into this next week, but essentially, sometimes employers will contract into what the notice period is over and above what the Employment Standards Act is, but that may not actually be a great deal for you because depending on a number of factors, you may be entitled to more. So it is important to kind of understand the termination and resignation provisions. And the other thing I wanted to mention is if you don't have an employment contract, it's not necessarily too late. But what I will tell you is don't ever get into a situation where you're contracting with an employer for less than you're already receiving. Even if you don't have a written contract, say, for example, they say, oh, well, if you want a contract, we want to pay you less. Then that's not okay. They're not allowed to do that. And it's, you know, it is okay to highlight that, you know, you shouldn't be contracting less than what you've already been receiving. And don't be persuaded by any of the employer's pleas about, well, if we're making this formal, it's going to cost us. That's just not your problem as an employee. The other thing I will say is if you don't have an employment contract and you're in any sort of an immigration process, I recommend you get one because, you know, with a few exceptions in the refugee context, sometimes those employment contracts make up part of necessary evidence that can be very helpful to your process. And so getting that written contract can be really important. But if it's not there and you need it for the immigration process, it's also possible to get a letter confirming employment from your employer so that you can provide that to immigration if that's something that's required as part of your process. Next slide, please. My employer asks me to work overtime, but doesn't pay me anything extra for this work. Is this legal, and what can I do about it? Short answer, no, it's not legal. And I want to highlight something as far as overtime. So for employees, let's say, for example, salaried employees who have set hours of work, and say, for example, you know, the odd Thursday, you're asked, oh, can you stay an extra hour and lock up, for instance? That extra hour is not necessarily overtime. There's a threshold, and there's a minimum threshold in the Employment Standards Act, which can generally be 44 hours a week at your regular pay, or it could be 88 hours at your regular pay, depending on the circumstances. And then the contract can also provide for specific instances. The number one thing is if you're working hours at work, you should be getting paid for that work. You may not necessarily be initially meeting the overall threshold for overtime. Say, for example, you're in a situation where it's 88 hours for every 2 weeks, then you would be receiving regular pay for those additional hours. And then beyond the 88 hours, you would be receiving overtime, unless you are one of those professions like mine that is an exception to the Employment Standards Act where overtime doesn't apply. And I think I mentioned earlier, and there's going to be a link at the end. The ministry's website can be very useful for looking at that information. They often have small write-ups with references on how to understand the Employment Standards Act. And so what you would look for is what are the exceptions? What professions are the exceptions? So lawyer is one, for example. Superintendent at an apartment complex, a residential complex is another. So there are situations where it is in fact legal, but it really is a matter of being an exception rather than the general rule. So if you think that this is happening to you, look up what the threshold is for you, and then look up whether your job is one of those positions that meets the exception. Next slide, please. What kind of information am I obligated to provide if my employer asks for medical documentation? So the sick notes. So generally speaking, I do want to make sure everyone's aware that under the Employment Standards Act, you're entitled to 3 unpaid sick days per year. That doesn't necessarily mean that you don't have to provide a sick note for those days. You may be asked to provide that. But what it does mean is if you have 3 days of medical absence, and keep in mind, that's different than what no longer exists, but did exist for the leave related to COVID. That's a separate thing. This is just generally protected 3 unpaid sick days per year. And employers can ask for medical documentation. It doesn't necessarily have to be a doctor. So for example, if you're part of a community health center and you generally see a nurse practitioner, for example, a nurse practitioner under the Employment Standards Act and with their scope of practice is someone who's authorized to provide a note. And what kind of information is on the note? Generally, duration of absence and the date seen. And so a lot of the sick notes that I see are crafted around employee X is unable to work for the next 3 days for medical reasons. For medical reasons, for a few days of sick time is all your employer needs to know. And I think sometimes employers, rightly or wrongly, there are some who do it in good faith and some who are just crossing a boundary they shouldn't be crossing, want more information. If it's just a few days, all they really need to know is how long you're going to be off and that you've had a medical professional confirm that it's for health medical reasons. They're not entitled to know your diagnosis. They're not entitled to know that sort of thing, what medications you're on, but they're entitled to know when you're expected to be back at work. And it's a good practice if, you know, it may be something, you know, say you break your arm and your doctor suggests that, you know, because of the severity of it, you should take a couple days off work. Try to schedule a follow-up within those couple days with your doctor. I know a lot of us are in a situation where accessing healthcare can be quite challenging. But if there's any chance you're not going to be able to go back to work before those 2 or 3 days are up, then try to schedule appointments so you can get it extended if that's what's required. The other kind of aspect to this question is, generally speaking, the longer you're off work, the more information your employer is entitled to. And so, for example, they could ask for a medical opinion, which often will include prognosis and expected return date. And sometimes that can be in conjunction with a short-term disability program your employer may have, a long-term disability program. It may be, if it's work-related, that it's WSIB, and that will often, more often than not, rather than a medical opinion, it'll be sort of a medical fitness for work. So what that generally can entail is, if you are, if you've experienced something that you have more restrictions than a general sick note will cover, for example, then when you return to work, you may be asked to get confirmation on your medical fitness to work, especially if your workplace involves a lot of safety concerns, to make sure that you can do the work. And what's a really good piece to have for that is some form of job demands analysis. So, for example, my work as a lawyer is going to be a lot different than someone's work as a bus driver, or someone else's work who's doing admin. So if someone is, working at a front desk and doing a lot of administration, then perhaps the restrictions of a broken leg may not really impede their ability to work. And that's important information, because that also gets into workplace accommodations and provides the employer with what those restrictions are. And if you're speaking with any employees, they should be asking their employer, a job description isn't generally enough, because a lot of job descriptions can be very general with regards to duties. More of a job demands analysis is preferred if your workplace has that, and that'll have physical things like, can you push, can you pull, what are the restrictions on that? So it's easier for the doctors to fill out, and generally that one is filled out by physicians, or sometimes a practice will have a kinesiologist that'll sort of assess it, and then the physician will provide, or nurse practitioner in some cases, provide a confirmation with their medical opinion on that. Some jobs have license requirements. So for example, if you're driving a truck, you may be required to have a medical examination. And that could be a condition of employment as well. And your employer is allowed to ask for that. And I did touch on return to work restrictions and accommodations. And that can be really a challenging thing, especially if, you're not really sure sort of how that'll impact your employment relationship. And what I can tell you is it's really important that you do get clear restrictions from your physician and or whatever health care practitioner is treating you, because the employer does, to a certain extent, which is to the point of undue hardship, which I know sounds very vague and requires additional explaining, is required to accommodate you. And so it's important to ensure that you're communicating what those accommodations are, because it's not enough to, for example, have a disability. If you haven't communicated that to your employer, then the employer isn't in a position to know what kind of accommodations that you require. And I think a lot of employees don't want to necessarily bring that up. And, you know, of course, everyone needs to gauge their workplace as their own. But if you need accommodations, then I do recommend speaking with your healthcare practitioner about how to ask for those. And those accommodations still are not inclusive of providing your diagnosis. So that information is confidential information. Now, if you're working for a larger employer, say for example, like a municipality or a larger employer that has more of a occupational health and safety or employee health and wellness type department, there may be a little more information that gets shared between those two, but those records, it's important you read their, I know nobody reads this, but I'm telling you anyways, read their privacy requirements, because the employee health and wellness will also generally treat all of that medical information confidential, but they will communicate the restrictions to your supervisor and that sort of thing. Next slide, please. So my boss touches me or my coworkers inappropriately. What can I do to make this stop? And I wanted to highlight there is a number of things that can impact your workplace that really have to do with harassment or violence. And so, because there's other types of harassment other than sexual harassment, but sexual harassment can be very, very difficult to experience and to address in the workplace. One thing I would encourage everyone here to do, and everyone who's potentially, you know, working with a vulnerable employee or someone with precarious immigration status, is get familiar with what your workplace harassment and workplace violence policies are. And I know it's boring, and there may be a video that's also seemingly boring, but what's important in those policies is that understanding within your specific workplace who you can go to when these things are happening, because a lot of the outside mechanisms also require your employer's knowledge and engaging with those internal processes first. But I'll generally kind of define them a little bit. I could do a whole lunchtime presentation on this. I could do a whole day on this actually alone. But I'm going to give you the Reader's Digest version to differentiate, you know, how this works. And I just want to highlight that whether it's provincially or federally, provincially in Ontario, there is Occupational Health and Safety Act that governs this piece. And like the Ministry of Labor's website, the Occupational Health and Safety website for Ontario also has general information. And as a sidebar, whenever people are looking for resources, one place I do direct them to is Connecting Ottawa, because Connecting Ottawa also has kind of the finger on the pulse of a lot of local resources, both on their website and the people working at Connecting Ottawa. So they know, generally speaking, other resources if you're looking for information. So workplace harassment is defined as engaging in a course of vexatious comment or conduct against a worker in a workplace that is known or ought reasonably be known to be unwelcome. And it also includes workplace sexual harassment. And I'm just going to sort of pause for a minute here, because I'm sure many of us can recall unpleasant things that were said to us, about us, or you know, kind of objectionable conduct in the workplace that didn't feel very nice. And it can be really difficult to differentiate what meets the definition under the Act as workplace harassment and what is a very difficult working relationship. And sometimes, unfortunately, those two are very different things. And what I would suggest is, if you're in at least a workplace that has a human resources department, if you're unsure, see if you can speak to someone at Human Resources about behavior that's making you feel uncomfortable. The Occupational Health and Safety Act defines workplace sexual harassment as engaging in a course of vexatious comment or conduct against a workplace because of sex, sexual orientation, gender identity, gender expression, where the course of comment or conduct is known or ought reasonably be known to be unwelcome, or making sexual solicitation or advance, which is what the question is asking about, where a person making it is in a position to confer, grant, or deny benefit or advancement to the worker, and the person knows or ought reasonably to be known that the solicitation or advance is unwelcome. And workplace sexual harassment can be really ambiguous. And I know that sounds hard to believe, because often when we see the videos, they're quite obvious situations. But my experience is also that aside from very clear cases where workplace sexual harassment is occurring, there's also kind of the nice harasser who appears to be kind and touches your shoulder and hugs you and you don't feel comfortable. And that can, and sometimes people will explain it away. Oh, this person is just like this. And, we just kind of put up with it. And that's not really the answer. You should be engaging in workplace processes to stop the objectionable behavior. If you feel comfortable, then I would encourage you to say something. You have a right at the workplace to not be touched if you don't want to be touched, and that's okay. And it can be very uncomfortable to raise that in a workplace setting, but it is something that you have a right to raise. And then I would also make sure that you look at the policy and see if there is any type of reporting process. Some have written format, some have an online initial sort of document that you have to fill out. Even if you're not sure, if someone is touching you in the workplace and you don't want them to, I would report it. It doesn't necessarily mean that person's going to get fired. And in a lot of cases, that isn't necessarily even the outcome. But the most important thing for you, of course, is to make sure that you're taking care of yourself and respecting your own bodily autonomy and asserting your workplace rights. And that's easy for me to say, but I have worked with hundreds of people that is very difficult to do. And I will also highlight that sexual harassment also does get covered under the Ontario Human Rights Code. Workplace violence, there should also be a policy about workplace violence. That's usually fairly self-explanatory, and it usually has to do, generally speaking, with physical force or the threat of physical force against a coworker or someone who works for you. And it could be also an offense under the criminal code. I do want to also quickly highlight that WSIB does provide for some stress-related, work-related coverage. And so rather than suffering in silence and not necessarily seeking help, if you are experiencing health impacts related to that type of toxic workplace environment, see your healthcare practitioner. And if you are going to make a stress-related workplace claim, which can include potentially coverage from for accessing healthcare, then you have a 6-month deadline. I did quickly just see what if, I know we're saving questions to the end, but it's a good question. What if it's your boss? And so one of the reasons it's a good idea to become familiar with a or your supervisor, sorry. The policies is the policy is required to say who you can go to if it is your supervisor. And that can be really challenging because the person experiencing the objectionable behavior, you know, generally you kind of don't go over your boss's head. You don't, if you're in a smaller organization, you may wonder, how is this possible? So say, for example, you know, say my supervisor is, my direct supervisor is an executive director. If the organization has a board, then, you know, potentially if you're unsure, potentially going to the board is the answer. But definitely check your own. It can be more intimidating if it's a supervisor because you don't know what's going to happen. But if there's more questions about that, I'll address that at the end. Next slide, please. Oh, sorry, next slide. Thank you. Is an employer allowed to ask for Canadian experience when considering prospective employees? Again, the short answer is probably not. So the Supreme Court of Canada has ruled on this, and essentially employers can only ask for, and I use quotes there, Canadian experience if it's a legitimate job requirement where providing an accommodation would cause undue hardship. And what that means is legitimate job requirements. So sometimes an employer will say, well, it definitely is a legitimate job requirement, but that's always a matter of fact and law. It has to relate to the purpose or nature of the job. It has to be adopted honestly rather than for a discriminatory reason. Is it necessary to do the job? Is there a better way that would avoid or reduce the negative effect? These are some things that sort of courts will look at if, for example, someone is, if there is a job posting that has Canadian experience. And for those of you for anybody in an immigration process, I know that there is a Canadian experience class that is related to your work permit. That isn't related necessarily to your, like, the job requirement itself. And I know that people who have certain types of status who may not have permanent residence, for example, have a different SIN number. Sorry, my brain stopped for a second there. Have a different SIN number, so it can be really obvious to an employer. And say, for example, you're going to work in construction and they want to make sure that you have Canadian experience. I don't think a construction agency, for example, is going to get away with having Canadian experience, because despite the fact that, you know, perhaps winter impacts laying concrete differently, it's something that, you know, the employer can certainly train and isn't necessarily going to meet the threshold of undue hardship. Now, how does this work for you if, you know, you're in the hiring process? It's a tough one because not everybody has any clear evidence that they weren't selected for a job because they didn't have Canadian experience. But generally speaking, the hiring process should be clear and open. Job ads should talk about the exact skills and work needed for the job, and applicants should be given a chance to sort of show their skills during interviews. And you know, it is okay for an employer to make sure you are able to work legally in Canada, but it's not okay to simply not hire you because your work permit has an end date and you know, the extension of that is uncertain. Next slide, please. So my employer is requiring me to work from the office, even though I can do the work remotely. Do I have a choice in the matter? So employers do generally have the ability to determine whether an employee can work from home, including creating and modifying work from home policies. And this is, I think, going to be a big one as employers start bringing people back to work after. So some employers have already done that a long time ago, and some employers are still doing that. And many of us have enjoyed being able to commute down to our desk and work from that. But an employer doesn't even necessarily have to have a good reason. They do have the ability to dictate that. Now, there may be something in your employment contract that says that you have the ability to work from home upon request. There may be something, for example, in a collective agreement or a policy in, for example, in the federal legislation, where you can apply for a flexible work arrangement. It doesn't necessarily mean you're going to get it, but and then also, this is where many of us who advocate for people for disabilities in the workplace, this is where we are really hopeful that a lot of workplaces that have indeed now found they can provide work from home to keep their business going. If someone has a disability that requires an accommodation, then it can be something that you discuss with your healthcare practitioner. I would advise against asking your doctor to merely write a note that you'd like to work from home. Some doctors will not necessarily do it, but you do legitimately, if you're asking for a disability accommodation, you do have to have that you have to have a medical reason for it. So it's not just a matter of easily being able to ask for an accommodation. Rather, if you have a disability and you would otherwise not be able to work, but if you could work from home, you could still work, then that may be an accommodation to explore. So that was probably not the news everybody was hoping for on that question. Next slide, please. My employer wants to pay me in cash. Is that legal? So generally speaking, employers can pay by cash, check, and direct deposit. There are rules for each. So for example, your employer can't meet you in a dark alley at 11 p.m. and pay you your month's worth of wages, right? So generally, if it's a cash payment, then it has to be paid either to you in the workplace during work hours or something that you agree on, so that you feel safe accepting that kind of cash. And employers can pay by check. I think many people have moved to direct deposit, but check is still very much a legitimate form of payment. Now, so that's just generally speaking how the Employment Standards Act treats cash payments. But there's also the other element of if you're receiving cash payment, is that what's known as being paid under the table, which isn't legal either for you or the employer. And there are legal consequences and potentially immigration consequences for that. So generally speaking, it's not automatic that if your employer pays you in cash, that they are not paying you legally. And the best way to tell is by getting pay statements. If you're not getting pay statements, ask for them. If you're in an immigration process, definitely make sure that you're getting pay statements. And that will tell you if the employer says, no, I'm paying you under the table. I think some people think, well, if I'm not paying taxes, then I'm going to make more money. And I haven't generally seen employers who pay cash actually paying their employees more for their work. But what I can tell you is the Income Tax Act in Canada requires that you report all income. And if you're not reporting that income, there are tax consequences. And if you're in an immigration process, there could be really serious immigration consequences. So I definitely don't advise that. Next slide, please. My employer is asking me to pay for faulty work or missing cash property. Do I have to pay? Again, generally speaking, no. So there's only a few things an employer can deduct from your pay. Statutory deductions like CPP, employment insurance, the tax, court order deductions. So say, for example, if I have a family law order essentially to pay child support, and that goes through the Family Responsibility Office, I may get those deducted from my pay, and deductions that are authorized by you. So for example, if your employer has like a education, no, that's a reimbursement, sorry. If your employer has, I recently dealt with an employee who actually had kind of a education, this is why I was thinking of education, an education loan through employment, like and you had a contract to kind of pay that back. If you sign that contract, you've agreed to have those deductions paid by you. Some people also try to get, if you're working more than one job, they'll ask the employer to deduct more tax so that at tax time they don't get a big tax bill. This rule applies to wages. So there are some exceptions, such as there could be an employment contract provision for bonuses that deducts for shrinkage. So if you're a salesperson and you're selling vacuums and you lose a hose, it could be in your employment contract that that shrinkage comes out of your bonus, but not your wages. If you break a dish and you're working as a server, and the employer can't deduct that from your wages, and there's rules about how it applies to tips. But one thing I also want to highlight before my time's up and I'm taking questions is the employment contract can also provide for a formula for calculation of wages. But keep in mind, so there could be a formula for the calculation of wages that in the employment contract deducts for shrinkage, but that deduction can't equal to the minimum wage entitlement. So remember when I say, if you're not one of the exceptions, if like a student, for example, if you're not, you can't contract out of the minimum standards of the Employment Standards Act if you're subject to the Employment Standards Act, unless you're sort of fitting in one of the exceptions. And that's it for my slides. Actually, I just want to quickly, I'll go for resources at the end in case anybody asks a question that conveniently fits nicely into these resources. So I'll turn it over to, I think Liz is moderating some of the questions.
I am. Thank you, Jamie. I wish we could keep you here all day, but we will get into some of the questions right now that people have asked in the chat box. So the first question is, what if time in lieu of pay is given for overtime? Can you maybe just explain the difference?
Yeah, of course. Some people and some employment contracts do have a preference that rather than getting paid, they would like to bank that time and take that time in lieu. So for example, if if you want to put it on resource slide, Gina, I'm fine with that. I can work from the other one. The question was, I forgot my question.
Oh, sorry. Just to explain the difference.
Time in lieu. Yes. Time in lieu. So your employer could, in your employment contract, for example, give you an opportunity to bank time in lieu and take that as time off. So that can be especially beneficial for people who are only entitled to a small amount of vacation. They may want to bank their time in lieu rather than receive it on their paycheck. One thing I would definitely recommend is if that time in lieu doesn't appear on your pay statement, then make sure you keep your own records, because if your banked time in lieu, if you don't have records of it, then that can be problematic. And banked time in lieu can apply to both additional hours and overtime hours. And so, for example, overtime hours, which is paid at your hourly wage plus, so it's time and a half. So 1.5 times your regular rate. If you want to bank that, then that is something that you may be amenable to, and it is perfectly legal to do it. It is very important though that you do, and if, for example, that employment relationship ends and you've built up all of these hours and you haven't been able to take them, that's something that you obviously can demand upon termination. Or I won't get into how that employment relationship ends, because John's going to talk about that in much more detail next week, and he's amazing. So I hope you're looking forward to that one. But you are still owed that time. It doesn't go away. It is something that you have earned, that you're entitled to. Where it gets a little bit sticky is sometimes after an employment relationship ends, the employer will say, oh, yes, but to work that overtime, that person needed permission. And so I do recommend that people keep track of their own hours, even if you work for the bestest, most wonderful employer in the whole world and nothing will ever impact that relationship. If you're a paper person, go to Dollarama and get a notebook and record your hours and record your notebook and record your overtime hours, your additional hours, and anything you're banking in time of lieu. And if you were told to work that, who told you? Because that can be used as evidence if you're making it a claim with the Ministry of Labor. I hope that answers your question.
It does. Thank you, Jamie. So the next question is with respect to medical documentation. Is there an expectation that you'll have to provide more medical documentation the longer you're on leave? And I guess to add to that, what are the implications of not providing this documentation if it's requested? So what would be reasonable for an employer to request?
Yeah, so if you're off for a number, like say, for example, you're going to be off and you're going to wind up meeting the threshold for long-term disability in your workplace, as an example, you could be required to fill out, and it'll depend on your employment contract, whether that's at your own expense or your employer's expense, a more detailed form that will talk about your restrictions, because what they want to be clear of is that you're unable to work in your occupation for medical reasons. And they may also explore whether you're able to work in another occupation or not due to medical reasons. And an employee, just sort of answer the second half of that question, if you're engaging in any sort of accommodation process, which can include extended sick leave, then that an employee is required to participate in that. What's reasonable can really depend on the circumstances, but if you're refusing to provide that note, that could wind up in termination ultimately, if essentially, because what that would be would under those implied rights I mentioned at the beginning, this is very Reader's Digest version, it would be absent from the workplace without necessarily proper documentation, medical documentation supporting that medical related absence.
Thank you. So the next question, this might have to be the last question. Does a potential employee need to provide their social insurance number prior to their start date?
Generally speaking, yes. and it's a good thing when you're asked, because that's how you're sort of registered for both. That's the other thing I forgot to mention, and I'll quickly add that at the end. Employment insurance and taxation type registration. So that also validates that you're working lawfully with that employer. If you're in a situation, for example, where, due to COVID, there's been a delay and you're in a queue to get your social insurance number, then it could wind up delaying your start date. But if you have a temporary number, that is sufficient to start your employment.
Okay, thank you. And maybe
Sorry. And the added thing I wanted to mention earlier that I missed in my notes is, if you're working for cash under the table, there's also implications where you will not receive employment insurance if you need it, because you don't have, that's the big one, and I think it was obvious. But that is the biggest impact on a worker. So for example, if you're underreporting your total income as well, which does happen, that can also be problematic if you wind up having to go on EI and then you're not able to access those full benefits. Sorry, Liz, I interrupted you.
No, that's okay. That's a really important point, because we do come across cases like that at Connecting Ottawa. We'll maybe fit in one more question, and this is, I guess, with respect to overtime. If a position requires me to work on weekends, should this be stated upfront in the job description at the time of hiring?
It always depends. So generally speaking, and it's funny, lawyers always say that because it always depends. But generally speaking, an employer can require you to work, like they are sort of in charge of the hours, where that's where an employment contract can be really helpful to start off clearly with that employment relationship. So, for example, you're working 8 to 4 Monday to Friday, and you have unpaid breaks and a paid lunch, for example, or paid breaks and an unpaid lunch. So it's undesirable, but I would recommend, if that's something that's going to be a concern for you, then ask those questions in the interview too, because that can help you decide or not decide to take that position. It gets a little more complicated if there's a change in your workplace, and that gets into what does the employment contract say, and a lot of different things. And I don't think there's enough time to answer those questions. So, but I will say that generally speaking, employers do enjoy the privilege of kind of setting your hours and when you work. And I did just want to add, because I didn't go through the resources. So the first resource, the Ontario Ministry of Labour Training and Skills Development, you can actually make complaints under certain circumstances. So if you Google that, that's actually a hyperlink if you do click on that. So I don't know if the slide deck is being sent out, but the only thing I would ask if it is just get rid of my messy notes, because they're not the clean ones that I have now at the bottom. But that link can take you to information for if you want to make an Employment Standards Act claim about unpaid wages, unpaid overtime, and a lot of different things. You can look at that piece, and it is accessible. You don't need a lawyer to do it. And you can call, they have a number you can call to get more information as well. Ontario Occupational Health and Safety also has a complaints mechanism, and they can also give you information on work refusals, which can apply in certain circumstances for harassment, but I definitely recommend you get more comprehensive advice if you want to engage in any sort of work refusal. Human Rights Tribunal of Ontario is also intended to be accessible to people, and they do have a fairly easy to read website that also provides some general information on different aspects. WSIB has that information. Connecting Ottawa, who I absolutely adore as a community resource, and they're kind of the people in the know, especially when it comes to grassroots things going on. And their website is, I send stuff from their website to people all the time. And I wanted to make sure people are aware of 211 as well. 211, not to be confused with 311, is a phone resource, and they're also pretty good with knowing what's out there. So for example, if you have questions about where do I call if I'm looking for free legal information about my immigration employment related question and I can't afford a lawyer, 211 may refer you to the community legal system, for example. So I just wanted to provide that. Thank you very much to Connecting Ottawa for inviting me here today, and thanks for all that you do.
Jamie, thank you so much. You're busy and you have a lot going on, and we so appreciate the time that you took to be with us today to share your knowledge. And to everyone who attended, thank you so much. It was so great to see the number of people out. Please, if you haven't already, register for our session with lawyer John No next week, where, like Jamie, he will also answer a series of really important questions that I think it's important for all of you who are working on the front lines to know. You're going to receive an email in the coming days. It's an evaluation, and we encourage you to fill it out, share your feedback on today's session. We'd love to hear from you. Thank you again for supporting us, and thank you to the Law Foundation of Ontario for your continued support of our project. Have a great afternoon, and we hope to see you all next week. Bye.